Afternoon, sir.
Afternoon.
Okay, so this is the prosecution is now doing basically a cross on the defense's use of force expert. So he's going to try and use all his experts against this expert where they disagree.
So I'm understanding your testimony, you indicate as a fundamental proposition that the defendant's conduct of restraining Mr. Floyd in the prone position on the ground, handcuffed, was not a use of force.
That's correct.
And I believe, according to your testimony, it's because, in your opinion, that position is not likely to inflict pain. Is that correct?
That is correct.
Now, if it did, in fact, inflict pain upon Mr. Floyd, would that change your opinion?
Only if the positioning of the body or if the officers were manipulating Mr. Floyd's hands in a way that would create pain, then yes, I would say that would be a use of force.
So my question is, if Mr. Floyd actually experienced pain, would that change your opinion? Would it be then a use of force if...
It would depend. Is the pain coming from something that's in the officer's control, or is the pain coming from Mr. Floyd's resistance and he's causing his own pain? I guess if he's causing his own pain and you're trying to overcome that resistance, then it could be shared, but it would depend.
Pain was actually inflicted upon Mr. Floyd.
If the pain was inflicted through the prone control, then yes, I would say that was a use of force.
And the prone control, as we're describing here, just so that we make sure that we're talking about the same terms, would be placing Mr. Floyd on his stomach, correct?
Yes.
Face down.
Yes.
Handcuffed.
Yes.
And as applied here, on a hard surface, on the pavement, correct?
Yes.
Right. And so if we're talking about that as the prone, you're calling it prone control?
Yes.
Can I use it interchangeably with prone restraint?
I think
accept
they're
that
the
term? Okay. So I'll refer to it as a prone restraint. Mr. Floyd is face down, handcuffed behind the back, correct?
Yes.
This prosecutor's doing a good job because he's not coming off, right now anyway, in an attacking or you're full of shit or etc. He's asking reasonable questions and he's trying to get it. So I think both him and the witness is doing a good job so far.
And at some point, the defendant is on top of him. Is that right?
I think he had his knee on him. I'm not sure if I would describe that as being on top of him.
If I may publish to the witness Exhibit 17. All right. And so, as shown here in Exhibit 17, you're able to see the exhibit. Is that right?
Yes.
All right. And you see that the defendant has his knee on top of Mr. Floyd. Is that correct?
I see his knee in the vicinity of the upper back and neck area.
Is it on the top or the bottom of Mr. Floyd?
It's on his back. Top being top of the head, or...
You tell me, is it on the top, the bottom, the side? Where is his knee?
I see his knee on the upper spine and neck area.
Is the upper spine then on the top?
Okay, we can use top.
Okay, you would agree with me then?
Yes.
Okay. And so the defendant is on top of Mr. Floyd.
His knee is on top of his...
And you can't see where his other knee is in this photograph, is that right?
That's correct.
But you have reviewed the body-worn camera footage, correct?
I have.
And you've looked at the other exhibits that have been submitted in this case, or no?
Most of them.
Okay. And so you're aware that now what we're looking at here is the defendant's left knee on top of Mr. Floyd, correct?
Yes.
Are you aware at this point in time that the defendant's right knee is also on top of Mr. Floyd?
I believe it was on his arm or to the side of his body.
You believe it was on his arm?
Yes.
Okay. On top of him, though, right?
Yes.
Okay. And so, to answer my question, the defendant is on top of Mr. Floyd on Exhibit 17, is that right?
Again, when I say on top, I think he's laying his complete body on top of Mr. Floyd. What I see is the knee positions.
Okay. Both knees on top of Mr. Floyd?
Yes.
Okay. And also, are you aware?
I don't think the guy's, I mean, he's kind of sticking to a point that's, if and buts of coconuts. Look, his body position is higher than Mr. Floyd because he's holding Mr. Floyd down. But we have a prone restraint when we're on top of somebody. Cops talk of that, and when I tell you to prone someone out and get on top of them, use your entire body weight, that means I'm laying prone on top of you like we're in a grappling move, and I am pinning you to the ground with my body. And in this situation, he's using his knees to ensure Mr. Floyd doesn't get up. But if you want to say he's on top, that's fine, but my definition is on top is what I just described. I think he would have been better going that route.
Aware that the defendant weighed approximately 140 pounds at the time this took place? Were you aware of that by your review of the records?
Yes.
And in your experience, does the clothing and equipment that the defendant is wearing in Exhibit 17, could that add some amount of weight to the defendant?
Yes.
And that would then increase the amount of pressure or force being placed on Mr. Floyd at this time. Is that right?
It could.
Okay. And so looking then at Exhibit 17 and just starting with the fundamental premise of your testimony, that what we're seeing here is not a use of force, I need to ask you if you believe that it is unlikely that orienting yourself on top of a person on the pavement with both legs is unlikely to produce pain?
It could.
What do you mean it could? Is it unlikely to produce pain, or is it likely to produce pain?
I'm saying it could produce pain.
It could.
Yes.
And if it could produce pain, then
That was good that he didn't. See, attorneys want him to get into my definitions, this or that, and he stuck to his. It could. And again, it could produce pain. Why? If he asks why it could produce pain, I hope the defense comes back and goes, why did you say why instead of likely? Because if Mr. Floyd's under the influence of drugs, he may not be feeling any pain. So it could not be producing pain.
again, just looking at your premise, if it could produce pain, then it would be a use of force, wouldn't it?
If
I actually think it's a use of force whether or not it produces pain or not. If I put my hand on you and escort you, I'm using force. If I grab your wrist and it doesn't produce pain, I'm using force. So that's where I'm kind of different on this guy. I think he kind of made a not a good statement there that he's going to have to defend.
the officer's intent was to inflict pain, that would
Not
be
the
use of force.
officer's intent, sir. What you said is that it was unlikely to produce pain, and that's why it wasn't a use of force.
He didn't say it was unlikely. He misstated his testimony. He said it could. He did not say it was unlikely. You wanted me to say it was unlikely or likely, and I said it could. The expert didn't correct him because he's moving on to his next point. He's being slick. He got the jury to hear that he said it was unlikely, and now he's moving on.
Sir, what you said is that it was unlikely to produce pain, and that's why it wasn't a use of force. You now just said that it could produce pain. And so, regardless of the officer's intent, if this act that we're looking at here
Objection, Your Honor, he's testifying. That's not what he said.
in Exhibit 17 could produce pain, would you agree that what we're seeing here is a use of force?
Shown in this picture, that could be a use of force.
Okay.
I don't know about that could be. I think any officer is going to say, this guy he blew it on that one. That if you're kneeling on somebody, keep them on the ground, you're using force. That's physical force. Let me, if I was the prosecutor, I'd ask him, okay, let me ask you this. If the suspect was kneeling on an officer, do you think the officer would think that was a use of force? Of course he would.
If you would take that down, please. And sir, I'd like to talk to you a little bit about positional asphyxia, if I'm to understand your testimony about positional asphyxia. This is something that you're familiar with, is that right?
Yes.
This is something that you've taught in courses to budding officers, I'm assuming, the dangers of positional asphyxia?
Yes.
And in positional asphyxia, is it true that positional asphyxia is a result of some oxygen deprivation? Is that right?
Yes.
And that is as a result of a chest cavity, the inability for the lungs to expand. Fair?
Yes.
And in positional asphyxia, as understood in law enforcement, can be a result of having your chest, your body weight on the ground, right, in the prone position. Your own body weight, the subject's own body weight.
That could, yes.
That could cause positional asphyxia, just the body weight itself.
If the person is extremely obese.
Sure.
If you or I were to lie with our hands cupped behind our back on the ground, I don't think either one of us would be prone to positional asphyxia.
Well, I will take that as a compliment, just for the purposes of argument here. But there can be instances, certainly, in which a person, by nature of their own body weight, could experience positional asphyxia.
Could.
It's possible.
And things that could further exacerbate or contribute to that could be the use of restraint, correct? The handcuffs behind the back.
Yes.
And additional pressure as well. So you being a non-obese fit person, right? If someone was pressing down on you, that would sort of take the place of excess body weight, and that could contribute to positional asphyxia.
I'm not sure.
It's possible.
Yeah, I'm not sure I would agree with that one. If somebody put their weight on me, that doesn't take the place of me having a large, obese body, that my own body is putting that additional pressure, my own weight is doing it. Just because I put weight on somebody that's fit, it could, I guess, produce positional asphyxia, but I would have to be putting weight, stopping the diaphragm and the chest wall from impeding, which in this case, there were 2 or 3 officers, and they probably did do that.
And if the pressure, obviously, the greater the pressure being exerted, the more of a potential danger of positional asphyxia. Fair?
Yes.
Sure.
And dangers of positional asphyxia due to being restrained in the prone position is a known risk. Is that right?
Yes.
And it's something you know about, true?
Yes.
Yes.
It's something you teach in your courses, correct, in training?
Yes.
And this is something you've been in law enforcement, did you say since 1972?
For 79 years. Excuse me, 29 years.
Okay, 29 years. At what point did you become aware of the dangers associated with positional asphyxia?
Probably late 80s.
So, looking over 30 years that you've been aware of the dangers of positional asphyxia, right?
Yes.
And would you agree that that's something that's commonly understood in law enforcement, that this is a known risk?
Yes.
Okay, when he says it's commonly, when it came originally, when positional asphyxia first became an issue with law enforcement, a suspect died in the back seat of a car. They had him handcuffed. I think they had him hogtied, and they threw him in the back seat, and he died on the way to jail. And I don't remember the case, but that's when the new knowledge of positional asphyxia first came into play. It was like, hey, you can't handcuff a dude with his knees up in the air and handcuff because it cuts off the air supply when you throw him on top. And they can't breathe because they can't expand their stomach or their chest, and there's a problem. So don't leave guys in the hogtied position on their belly. That's how it first came out. Over time, I think it's become more to where, you know what, in this lawsuit time, try to get suspects off their belly as soon as you can. And I think that's the common practice. But as soon as you can is the key. Is it safe to do so with traffic? When a guy's fighting, when he's under the influence, when you have medical aid coming, when a guy's been fighting you for 10 minutes and now you finally got him in a stable position, do you want to take a chance and move him? So all those factors come into play.
This is not new information.
No.
And there are ways to mitigate against the risks of positional asphyxia that are known to law enforcement. Is that right?
Yes.
And I think what you testified to is the side recovery position. Can you describe the side recovery position?
So when a suspect is handcuffed, you just pull them to their side and have them tuck their knees up? Kind of like a fetal position almost?
Like a fetal position. Right. And so you've also been a defensive tactics instructor, correct?
Yes.
And you've been certified as such, right?
Yes.
Are you aware of how one might put somebody in the side recovery position?
It's fairly simple to do, just pull them to their side.
Okay. Does it take a long time?
No.
No.
So it's simple, it's fairly quick, and in your opinion, it alleviates or could alleviate against the dangers of positional asphyxia. True?
Okay. So what this attorney's doing is he's making it seem easy and the technique is easy, but he's taking it in an isolated incident and he's not taking it in totality. It's easy if I'm in a classroom environment on a mat and I can do it safely. I don't have outside threats. I don't have traffic. I have unlimited space and it's easy to do. It's a lot different in the middle of a situation when a crowd is yelling at you and you have traffic screaming by behind you and you've got a guy that's fighting you. There's a lot of difference. It's not so easy. That's what the use of force guy should have responded.
Yes.
Now, I know that you reviewed various MPD policies in connection with your review of this case. Is that right?
Yes.
And getting back to the issue of whether what we saw in Exhibit 17 at that particular time was a use of force, are you aware of how the Minneapolis Police Department defines force?
Not specifically, no. I would have a general understanding of it.
Generally, would you agree, or based on your review, would you accept that the Minneapolis Police Department generally defines force to include restraint?
Again?
Particularly if it's restraint that could result in some sort of injury or pain.
Yes.
Fair? And so you would agree then, just as we are at this point in your testimony, that what we saw in Exhibit 17 would at least fit within the Minneapolis Police Department policy of a use of force. Fair?
Yes.
And a reasonable police officer would adhere to the policies of their own department. True?
Yes.
Should. I'm not sure what his point is. So what if they're using force when he's on the ground? They have to use force. Was that force reasonable to overcome Floyd's resistance? That's the question, not whether or not they used force. Was it reasonable?
In your analysis of how, under the Graham factors, how you're going to go about a force review, you indicated that one of the things that you look at is the severity of the crime. True?
Yes.
And severity of the crime is something that, would you agree, the label of the crime, whether it's a misdemeanor or a gross misdemeanor in Minnesota or a felony, isn't as important as the underlying conduct involved in the crime.
I agree.
So a felony level bad check may, from a use of force standpoint, be less serious than a misdemeanor domestic assault. Fair?
Yes.
So by the nature of the terminology of the crime, I agree, but obviously domestic violence case is a serious and potentially violent environment.
And really, maybe that was an inartful question, but that's what I'm asking. In this case, the misdemeanor, what's labeled as a misdemeanor assault, would, from a use of force perspective, be more serious than, say, writing a bad check, but at a felony level.
I could, yes.
The underlying crime is how an officer evaluates when he first gets there. But the suspect's behavior can change all that, and then the crime becomes irrelevant.
And you're aware that in this case, the initial call that the officers were responding to was a counterfeiting allegation or forgery allegation, passing a fake $20 bill, right?
Yes.
And could you agree that in terms of the range of criminal offenses, this would be at a fairly low level from a use of force perspective?
Yes, but again, as I mentioned earlier,
Well, what I was asking is if you could
See, he cut him off. He didn't want to let him.
agree, and I'll give you a chance to explain if you want, but you would agree that in terms of the range of different criminal offenses that are available, a counterfeiting call over an alleged fake $20 bill is on the less serious side.
yes.
And I think what you probably were about to say is that, but that can change, right?
And again, it's all about the contact and the resistance of the suspect.
Right.
Bingo. Doesn't matter what the crime is. It matters what the behavior, what the actions of the person is, the actions of the environment, the crowd, other officers. If I've got two small women fighting a big guy, I'm going to use more force than if I have three strong big guys and we can control them without using more force. So it depends. It always depends.
Which is completely different than the seriousness of the underlying offense. That's why I stopped you. I didn't want to be rude, but let's just keep this in that analytical framework for now. Seriousness of the offense, not the response, because we'll get to that, the response to the subject.
Okay.
And would you say, would you agree with me that the response of the subject, the activities of the subject to the officer on the scene, that's probably the operative important facts here, right? That's what you need to look at.
Yes.
So in terms of seriousness of the crime, that's not as important. Let's take a look at the imminence of the threat. You discussed imminence of the threat. Officers have to assess that. Is that right?
Yes.
And could you please, for the jury, explain in your words what you mean by threat? What is a threat?
So he's trying to get in because he's got the list up there where his expert said there's a difference between risk and threat. And if this guy explains a threat has a risk, he's going to call him on it. But a risk and a threat is still an evaluation process of the officer. One officer may say, I think that's just a risk. Another officer goes, bullshit, that's a threat. It depends on the experience of the officer and his training. I see things differently because of my experience and my training than a rookie of 6 months or somebody that's been on for 20 years and they sat behind a desk and done, financial crimes for 20 years. We're going to see risk and threat a whole lot differently.
You look at a person and you can't see their hands. They have their hands in their pocket. That could be a threat, that in their pocket is a gun. You look at a person and the way they position their body, angle their body back into maybe a confrontational stance. That could be a threat.
Fighting stance?
All right. So right now I have both my hands in my pocket, and I'm trying to be confrontational. I don't know if I look confrontational, but am I a threat?
If I was walking up to you on the street and it's going to be reasonable suspicion that you have committed some type of criminal activity, I would, from a position of cover, ideally, tell you to take your hands out of your pockets.
Would you agree that there's a difference between a threat and a risk?
Yes.
And so really any person can present a risk, right?
Yes.
Someone could have their hands in their pocket and unexpectedly have a weapon. True?
Yes.
Or not.
Or not.
That's a risk. But would you agree that a threat is when I would be doing something to show some sort of intention to cause you harm? Balling up my fists, approaching you in an aggressive manner. That would be a threat, correct?
Some type of cues, yes.
Not necessarily. If you're a parolee and you're out on prison and you're not supposed to have weapons and you have a weapon and you're not reaching for the weapon and you're being cooperative and you got your hands up, but I see a gun in your pocket, that some people may go, well, that's just a risk because he isn't reaching for it. Bullshit. That's a threat.
And would you agree that officers are authorized to use force to respond to a threat?
Yes.
Officers are not authorized to use force to respond to a mere risk. Fair?
Correct.
So there are many different factors that could be a risk versus a threat. Someone who's a large...
This is word games to me. I don't... A risk and threat are almost, yin and yang. It doesn't matter. They're always together. How can something be a threat and not be a risk?
in stature. That could be a risk, true?
Good.
But that's not in and of itself a threat, is it?
No,
You can't use force on someone just because they're large, true?
that's correct.
The use of drugs or intoxicants, that could be a risk factor, true?
Yes.
And on that subject, with respect to what a reasonable officer understands about the use of drugs and alcohol, controlled substances, there's a whole range of drugs out there, right?
Yes.
And there's a whole range of drug users out there, correct?
Yes.
And there are some drugs that could cause someone to become aggressive, true?
Yes.
And there's some drugs that can cause the user to become somewhat sedate, true?
Yes.
And so just hearing that someone is, quote, on something, that is not necessarily a threat to the officer, correct?
Unless there's behavior that makes the officer believe that.
It's always behavior. It's always behavior in the actions. And sometimes the behavior is so slight that you can't see it. The way a guy is looking, if he's target glancing at my gun, if he's looking for an escape, if he's looking away when he talks, if he looks like he's about to run, I see a shift in his weight, his resistive tension when I touch him, that he's going to resist or pull away. It's always behavior. But it has to be evaluated not in an isolated courtroom to where we're talking about it like it's some far off distant thought. This is real, and it's at the time and in the eyes of the officer on the scene who has to make these decisions quickly and rapidly without the ability to have hindsight and figure it out and talk about it.
That the person's drug influenced.
Agreed. If there's behavior that they're drug influenced or behavior that they're going to be doing something threatening to the officer.
I
Because there's a
also-
difference, right?
Sorry, I missed something.
I'm sorry. There's a difference between someone manifesting behavior that they may be using drugs or manifesting a behavior that they're going to threaten you, right?
Again, but the manifestation of the drug influence could pose a threat.
Okay. But I mean, one manifestation of drug influence is that somebody's passed out, right?
Yes.
That probably does not constitute a threat to you, does it?
No.
That's more of a vulnerability of the person who's using the controlled substance, right?
Yes.
So,
And something else that they aren't bringing out is people who are under the influence of drugs commonly either carry weapons to defend their drugs and or carry more drugs. So the chance of flight or the chance of them not wanting to get arrested or deal with police is higher if they're under the influence because they probably have drugs on them.
so if someone is, quote, on something in and of itself, that is not a justification to use force, true?
True.
And if the person who is on something
Actually, I think he's wrong. I think the cop, if this guy's a cop, he should know that being under the influence in a public place is a crime. And if he's on drugs, he's committing a crime. And therefore, it is justified to use force, the minimum force necessary to take him into custody. So I do not agree that just because somebody's on the influence doesn't mean you can't use force.
is of large size, those two things combined, those two risks together combined, those don't justify the use of force, do they?
No, there need to be a third component, that is the actions of the suspect.
Right. The behavior of the subject, what they did. Fair?
Yes.
I wonder if he's going to ask him what George Floyd did, because George Floyd did a lot, and none of his experts want to talk about it. He kicked, he tried to get up, he fell on the ground, he pulled away from officers, he fought when he was in the back. When they got him on the ground, he was trying to roll over. Again, his actions dictated why the officers had to do what they did under the circumstances that they did. He keeps bringing up the concrete sidewalk like they brought George Floyd over from the soft mattress and put him on the concrete on purpose. The concrete was there. The officers didn't choose that. It just happened there.
Also, just in terms of the decision of an officer to use force, that is driven by the behavior of the subject, correct?
Yes.
The decision to use force on a subject is not dependent upon what some third party over whom the subject has no control and is not directing is doing, correct?
I'm not sure if I understand the question.
Let's say that
I know where he's going. He's trying to say that, yeah, I can't use force because I was worried about the crowd. But I'm not sure I would agree with that. I can't use force on somebody that I'm not justified using force on for some other measure. But if I have somebody in my custody, the crowd or the situation may dictate that I need to use more force on that subject to move him, to snatch him, to throw him on the ground, to throw him behind cover. I mean, if you're telling me that I've got somebody in my custody and somebody starts shooting at us, I can't use force to pull him out of the way of the gunshot or to pull him around a corner, because that would be force in your mind, and you're telling me I can't use that on what a third party does. That's incorrect. None of this is in a vacuum. And use of force experts need to be able to articulate and get these scenarios out so they know that, you know what, anything can happen. None of this is in this safe courtroom where this attorney wants everybody to think it is.
That you're distracted by something Mr. Nelson is doing. Let's say maybe he's even threatening you. That's not a justification for you to use force against me, is it?
No.
No, but if I have you in my custody and he's doing something that endangers you or me, then I can use force to move you where I want you to be. And that would be me using force because of what a third party did. So you saying that I can't do that, I think, is inappropriate or incorrect.
Because I certainly have no control over Mr. Nelson, right?
Correct.
All right. And so if there are, for example, in the instance of a bystander, if a bystander is doing something that an officer finds threatening or irritating or distracting or annoying, those activities don't justify a use of force against someone who is not directing those activities. Fair?
Yes.
Fair. However, but, the crowd distracting me and making me perceive them as a threat or a possible bigger threat may cause me to continue to do what I'm doing in a force situation in order to stabilize or not get distracted to where I get hurt or I don't lose focus and I end up having to deal with one of them and defend myself from the crowd, and then I let George Floyd get up, then he runs out into traffic and get runs over or trips and falls and breaks his neck. Then you would be saying that I should have used force or reasonable force to protect and detain Mr. Floyd. So you can't have it both ways.
It might explain the officer's state of mind in a particular moment, but it's not a justification for the use of force. True?
I agree.
He's driving that home, and this use of force expert is not getting out that that's not an if or an and or a but, and it has to be one or the other. It's not that simple.
You talked about situational awareness, and situational awareness is something that is important for, I think your testimony was anyone, and we can agree with that, right?
Yes.
But in particular, situational awareness is something important for an officer, a reasonable officer to have, correct?
Yes.
And that situational awareness has to include really under Graham all the facts and circumstances, the totality of facts and circumstances that are presented to the officer at the time.
Correct.
Yes.
And in looking particularly at the behavior of the person upon whom force is being applied, it's important that the officer is situationally aware of the condition of the subject, correct?
Yes.
That's one of the factors. But unfortunately, that's not his only job. And he can't sit there as a medic and go, let me be concerned just about the medical of this person. Because he's got a gun on and he's taking an arrest and he's taking action and he's using force and he's defending himself from the crowd and the environment. And there's many other factors such as the traffic, etc. So in your situation, you're saying it's one of our responsibilities, but it's not the primary only responsibility that we have to focus 99% of our attention on, and then we end up getting killed or run over because we're worried about a suspect that was committing a crime and fighting with us and caused us to put him on the ground. And now I'm going to get run over by a car because I'm worried about his medical condition. So it's not in an isolated vacuum. Man, this expert needs to freaking fight back on this guy.
Because if the subject does something aggressive, they need to adjust their plan and the use of force, correct? Their application. Yes. But if the subject is manifesting compliance or a medical condition, illness, then the officer needs to be situationally aware of that as well. Fair?
Should.
Do you agree, and having read the training materials and you're aware of MPD policy, and I'm assuming you've listened to some of the testimony in this case as an expert, you're allowed to do that?
I listened to 2 testimonies from the use of force experts.
All right. Do you agree with the proposition that in law enforcement, once somebody is in your custody, they're in your care?
I agree.
And in fact, that's the MPD policy and training, in your custody, in your care, correct?
Yes.
And situational awareness, then, would you agree, sir, that includes being aware of the subject's medical condition?
Yes.
But when I'm in the middle of dealing with a crowd and a fighting suspect and traffic in an uncertain, unstable condition, it's very hard for me to pull out my medical kit and do an EKG on this guy to make sure he's not having a heart attack. And then they would be pissed then because their whole thing has been like he didn't have a heart attack. But that's exactly probably what I would have said.
Particularly if they're exhibiting signs of distress.
Yes.
Loss of consciousness.
Yes.
Inability to breathe.
Yes.
Loss of pulse.
Yes.
All of these things a reasonable officer should take into consideration when determining whether to escalate force, de-escalate force, or remain the same, correct?
Yes.
Now, would you agree, sir, that the application of use of force must be reasonable at the start and at the end? True?
I agree.
And at all points in between?
Yes.
And if there's ever a point at which the use of force becomes unreasonable, that it must stop?
Or de-escalate.
Or de-escalate.
Good
It
answer.
must de-escalate to a point of being reasonable, correct?
Yes.
Because that's really the standard, is that of reasonability, right?
Yes.
Yeah. And in terms of proportionality, you've read the materials, you've studied the MPD policies, you're familiar with the MPD Defense Tactics and Control Guide continuum, use force continuum?
Yes.
Okay. And you would agree that that continuum, which we've all seen, is a tool that an officer can use to make some kind of a rough approximation of what is a proportional response. Right?
Yes.
When it's safe and secure to do so, it is not the primary goal and the only thing that the officer has to worry about in a chaotic situation.
You would agree, based on your review of Minneapolis Police Department policy, that the sanctity of life and protection of the public, those are the cornerstones of Minneapolis Police Department's use of force policy. True?
Yes.
In your review of the Minneapolis Police Department manual, the use of force manual, you received a copy of the manual, I'm assuming? Use of force?
5-300?
That's correct, 5-300.
Yes.
In your study of Minneapolis use of force policy 5-300 series, did you see the phrase or term one-upsmanship anywhere in this policy?
No.
So you would agree that one-upsmanship is not the cornerstone of Minneapolis Police Department's use of force policy. It's protection of the public and the sanctity of life. True?
And I use the phrase one-upmanship to describe how the standards of police training throughout the country are.
You're using one-upmanship to describe the concept of proportionality. True?
Yes.
And one-upsmanship is, I guess if that's an accurate description of what you're trying to express as far as proportionality, wouldn't that suggest, what is the limit to the one-upsmanship that an officer can do?
As I described earlier, that if a person...
Well, what he's talking about in the one-upsmanship is we don't have to meet force with force. If you pull a club on me, I can shoot you and use deadly force, because a club in your hands is considered deadly force because you don't have restraints, you don't have policy, and you don't have training, and you don't have target areas that you can't hit. When a police officer pulls a baton, he has target areas, he's been trained in it, he knows where not to hit to create deadly force. When a citizen who isn't trained pulls a bat or a stick out, they don't have that, which is why we can go one up and go to deadly force because he's using a weapon against us. But the citizens can't say when an officer hits them with a baton that they're allowed to use deadly force because we are trained in that technique. If a citizen shoots me with a taser, I can use deadly force. When I tase somebody, it is not considered deadly force. It is a lower level of force. That's what he's trying to explain on the one-upsmanship. He just didn't do it real well, and this guy's kind of eating his lunch with him, and he needs to explain that, look, we don't have to fight fair, and whatever force you use on us, we can go higher force because we have to go higher to stop that force. It's kind of like if we want to write somebody a speeding ticket, we have to be able to go faster than they're going to catch them. We can't say, oh no, you can only go as fast as suspect. Well, you can't just fight a suspect with the same resistance because we have to overcome their resistance, which means we go higher. And that's what he needs to get out.
Person tries to strike you or kick you, that the officer doesn't have to respond with their own punches or kicks. They can respond with a better tool, which would be an impact weapon or a taser or pepper spray. If the suspect were to grab hold of the officer's baton or taser, then the officer may find themselves in imminent threat and respond with potential deadly force.
Right. And I think the examples you used were strike you, stab you, shoot you, were some examples that you were talking about in terms of one-upsmanship, but that wasn't the answer I was looking for. In terms of one-upsmanship, isn't what the officer is always limited in their response by the Graham versus Connor standards of reasonableness, right?
True.
And so
It doesn't matter what Graham versus Connor said about reasonable. Reasonable force is defined as what a reasonable officer would do. And the standard for officers are, we cannot lose because we bring a gun to the scene and we are taking action to take people into custody. And if we lose, the suspect can get hurt, other people can get hurt, and we can get hurt, which is why we don't have to fight fair and which is why we go higher on the force scale than is what being used against us.
whatever step the officer takes to either escalate or de-escalate, it must be objectively reasonable. Correct?
I agree.
And that's why someone who is not resisting, who is being compliant, that's why that person cannot have any force at all exerted against them. Is that right?
No, that's not right. Because just because a guy stops using force does not mean I have to stop using force. If I take you into custody and you're fighting me and you try to kick me and I put you on the ground, just because you stop kicking me does not mean I have to let you up and take the handcuffs off. That is not correct. See, he's kind of baiting this use of force guy and the use of force guy is kind of going along with it instead of fighting back, in my opinion.
I don't agree with that.
If a person is not resisting and is not non-compliant, so let me phrase it better, compliant, officer's not justified in using force if they're being complied with.
So they'd be using control if the suspect's in their custody.
And control, under your definition, like if we're looking just at pure control, that is a restraint that's not likely to inflict pain, correct?
Yes.
That's control. But you've agreed that
Control is still force. I don't care if this guy keeps wanting to make pain equal to force, and it's not. If I put my hands on you, that is considered use of force. I am physically manipulating, moving, or putting my hands on you. That is force. That's why if you push somebody, it's an assault.
at Exhibit 17, what we saw here in this case, was likely to produce pain. True?
It could.
And so if someone is not resisting and they're compliant, the use of something, a control as you put it, that could produce pain is just not justified, is it?
No.
And we talked about the use of force needing to be appropriate reasonable from the beginning to the end, and at all points in between. Is that right?
Yes.
And the officer must reassess the situation, must reevaluate the situation, must be taking in information. Is that right?
Yes.
And that can include information from the suspect, the person upon whom they're using control, correct?
Yes.
That could be information that they're getting from other sources. For example, fellow officers. True?
Yes.
If a fellow officer makes some comment or assessment as to the condition of the subject, a reasonable officer takes that into account. Is that right?
Should.
And
Depends.
that information we use to factor in to reassess the situation to determine whether or not force should be escalated, de-escalated.
It depends if he hurt him. It depends if he thinks that's a priority right now. It depends if the officer that gave him that information has less experience and he doesn't necessarily agree with it. I can't listen to every other officer on what I feel when I'm using force. I have to justify my force on what my knowledge and my training is, not on what someone else is. That's why another officer can't tell me, shoot that person. If he wants to shoot him, he can shoot him. I don't shoot people because somebody told me. And I don't stop using force in a dangerous situation because somebody else may mention something.
Or discontinued. Fair?
Yes.
All right. And you would agree, we were talking about the threat assessment, you were talking about stabbing, striking, shooting. You agree that based upon your review of the evidence in this case, there was no stabbing attempt by Mr. Floyd, correct?
Correct.
He wasn't trying to shoot anyone, correct?
Yes.
Right. And we should talk about the specific circumstances here of what happened on May 25, 2020. Would you agree, as a general premise, that Mr. Floyd was handcuffed, restrained in the prone position for approximately 9 minutes and 29 seconds?
Yes.
And during that 9 minutes and 29 seconds, did you note any significant difference in the manner in which Mr. Floyd was restrained?
No.
Did you note any differences in the manner in which Mr. Floyd was acting during that entire restraint period from the first point to the 9:29? Did you notice any differences with him?
Yes.
For example, when he first was placed prone on the ground, he was speaking, correct?
And actively resisting. Yes.
And actively resisting when he was prone?
Yes.
Okay. How long did that take place?
I'm not sure. I'd say a couple minutes.
A couple minutes that he was actively resisting?
Yes. Struggling against the officers.
Yeah, I don't know if I would say a couple minutes. It took, there was a time when he first got out of the car that he was fighting getting out of the car. He was fighting while he was going to the ground. He tried to kick the guy and he tried to roll over and spin on the officers. And that's why it took 3 officers to hold him down on the ground. So until 3 officers got on him, he was pretty much actively resisting.
Okay. All right. Well, let's talk about the point when Mr. Floyd, when the restraint of Mr. Floyd first began. And I'd like to show you a clip from Exhibit 127, which is a composite of the King body-worn camera and the Frazier video. And that's going to be starting at 2019-09, which can we agree is around the beginning of the restraint period, based on your review?
I was looking for a screen. Sorry.
Oh, I'm sorry.
I missed that question.
All right. The King body-worn camera. Right? Right around the time of 2019-09, would you agree that this is right around the beginning of the restraint period?
I'll have to go with your approximation on the time.
And when we pull up the clip, why don't you pull up the clip and we publish it and hit pause right away. All right. So you can see the notation on the top of the screen at 2019-09.
Yes.
Would you agree that that's the beginning of the restraint period, is towards the beginning of the restraint period?
No.
You agree?
I'm not sure, but I'll take your word for it.
All right. Well, why don't we just watch it? And this is going to go through 2019.
They were restraining him long before that when he jumped on the ground, before they got him in the car. They were trying to restrain him, getting him in the car. They were trying to restrain him in the car. So this would not be the point of a restraining period, in my opinion.
And so right around 2019-09, right, when we first saw the clip, Mr. Floyd was standing or kneeling by the squad car. True?
Yes.
And did you hear what Mr. Floyd said when he was kneeling at the squad car?
Thank you or something to those lines.
Now, I want to back you up a little bit just in terms of situational awareness. And you're aware that the defendant received many hours of paid training by the Minneapolis Police Department, correct?
Yes.
Right around 889 hours, correct?
Sounds about right.
You familiar with crisis intervention training and what that is?
Yes.
You're aware that the defendant took a 40-hour course in crisis intervention training?
Yes.
And that generally is education to make people aware of different impediments to compliance, such as mental illness or intoxication. True.
Yes.
Anxiety would fit in there, correct?
Good.
Just because I know about crisis intervention and I know that this is a crisis and he may have, that doesn't stop the fact that I have to get the guy under control before he hurts himself or hurts me.
Perhaps claustrophobia.
Good.
Right. And when Officer Chauvin, the defendant, first approached the vehicle, and this was before Mr. Floyd went in, right in the back, and when he first got on the scene, through Officer Chauvin's body-worn camera, you could hear Mr. Floyd saying that he had anxiety and claustrophobia, correct?
Yes.
And then there was a struggle, and you observed the struggle in the back of the car when the officers forced Mr. Floyd in the back of the car, right?
Yes.
And then when he came out, he was kneeling right around the time we were looking. He was on his knees. He's handcuffed, right?
Yes.
And he says, "Thank you," right?
Yes.
And it was after that point that Mr. Floyd was then pushed over by the officers onto the ground, correct?
Yes.
And at the time he was pushed onto the ground, and just taking note of his body position, when he was initially pushed onto the ground, would that have qualified as a sort of side recovery position?
We'd have to back it up, and I'm not sure how long he was in that position.
Yes. About the time he kicked,
And so when he was
would have
were you able
been.
to see that?
I was.
All right. So when Mr. Floyd was initially brought from his handcuffed position on his knees to the ground, right, he was in effectively a side recovery position. Fair?
Momentarily, yes.
And then he was taken out of the side recovery position by the officers, and then after that point placed in the prone position. True?
Yes.
Well, he's making it sound like he was in a side recovery position, like it would have been nice to hold him there. Had Mr. Floyd not kicked at that point, maybe he wouldn't have been rolled down. But the fact that he kicked meant we couldn't keep him in that position, or the officer, a reasonable officer, wouldn't keep him in that position because he still has the ability to kick and hurt an officer. And that kick could be considered deadly force. If he kicked that officer into traffic and a car ran over that officer, the officer could have died. So, I mean, this sounds like it was like the officers just wanted to throw him on a hard pavement, but it really wasn't.
And so right after this clip runs, we see Mr. Floyd in the prone position. Correct?
Yes.
Face down on the ground, handcuffed. True?
Yes.
And the defendant and Officer King and Officer Lane then thereafter all took part in restraining Mr. Floyd in the prone position on the ground, based on your review, correct?
Yes.
And you were able to see then from Exhibit 17 that the defendant had one knee at least on Mr. Floyd's body, on his neck, in the neck back area, correct?
Yes.
Okay, on top. And you could see that he had his other knee also, I believe you said, near his arm, but it was on his back, correct?
I really couldn't tell from that picture. I took that from the snapshots of the body-worn cameras.
And so when you say that, you're agreeing that the defendant was on Mr. Floyd's neck.
This guy's demeanor has not changed. He hasn't got more defensive. He hasn't got more aggressive. He's pretty consistent on where he stands. And I don't detect any, I mean, obviously he's a defense witness, so he's biased only by the fact that he agrees that the defendant used reasonable force. So that's his bias. But his testimony is not like he wants to fight everything that doesn't support his bias. He's just kind of stating the facts a lot. So I'm okay with this witness.
Neck and back, at least at some portions of the restraint. Fair?
I would say upper back in the proximity of the neck, and then his right knee was towards the more of his rib cage.
On top of it, though, correct?
Yes.
Adding to the pressure. Fair?
Good.
Sir, I'd like to show you, just for a little more clarification, Exhibit 240, which has been received into evidence, and this might provide a better view. Okay, And so you testified just a moment ago that you thought that the defendant's knee was where?
Upper back and neck.
Okay. And so would you agree on placing a circle? Would that be Mr. Floyd's back, upper back?
That would be his upper back.
Okay. And I'll just place another circle. That's the defendant's knee,
It is?
his left knee. That's above the area that you've identified as Mr. Floyd's upper back, isn't it?
Yes.
His left knee is on Mr. Floyd's neck in this picture, in Exhibit 240, isn't it?
In this picture, yes.
Okay. Now I'd like to talk about his right knee. And you can see Mr. Floyd's arm, where I'm drawing, correct?
Yes.
And you can see the handcuffs, correct?
Yes.
Okay. And this is the defendant's right knee, correct?
Yes.
Would you agree that the defendant's right knee is on Mr. Floyd's lower back?
Looks like it's on his shoulder blade area to me.
Okay, so the shoulder blade area would be that. Would you clear that, Your Honor? I seem to have trouble here. I appreciate that. So the shoulder blade area, then, I guess that would be Mr. Floyd's upper back?
Yes.
Okay. So you would agree, based on Exhibit 240, that the defendant on his left knee is on Mr. Floyd's neck, his right knee is on Mr. Floyd's back, correct?
Yes.
And I believe your testimony earlier was that you've watched the entirety of this body-worn camera videos, true?
Yes.
And you would agree with me that there's a wealth of body-worn camera video footage in this case, true?
Yes.
And milestone video and surveillance video and bystander video, correct?
Yes.
So you're able to view, as an expert, the conduct here from multiple angles, true?
Yes.
And so with that sort of, I guess, redundancy built into the record, does that alleviate some of the concerns or considerations I think you were testifying to on your direct examination regarding how cameras react to light?
Yes.
Okay. So this exhibit 240 is actually an image taken, you can see it's at 20:19:27, that's about 13 seconds after the defendant placed Mr. Floyd in this prone position. You agree?
He was one of the three that put him in the prone.
Sure. After, and so we'll say, after the defendant and the two other officers put Mr. Floyd in the prone position, restrained on the ground, correct?
Yes.
All right, and then the first video that we play would demonstrate then that this restraint that we're talking about, which you said was a controlled restraint, or what was the term you used?
Prone control.
Prone control. That began around 2019-14. Fair?
Okay.
Okay. And I believe you testified that from the beginning to the end, you did not see the defendant's relative position on Mr. Floyd's body meaningfully change. Did you?
Can you rephrase the question?
Did the defendant get up from the point in which the prone restraint began and the prone restraint ended?
Did he get up?
Did he get up?
No.
Right. Did he let up off of him any pressure?
It appears that his body position changed, and he was putting more weight over his calves as the restraint continued.
And are you able to identify, based on your own review, because I know you've looked at this, correct?
Yes.
And I'm assuming you've looked at it a lot in preparation for testimony today, correct?
Yes.
Are you able to point to any particular portion of the video record in which you say that the defendant shifted his weight more towards his calves to take pressure off?
I would have to see the 14 body camera snapshots, and then we can focus on those.
So I'm going to show you another portion of the body-worn camera video, and that's going to be at, it's been received as Exhibit 127. It's a composite of King's body-worn camera and the Frazier video. We're going to start at 20:23:11. It should be Exhibit 127. It should be composite of King. Let me see, starting at 2023. This starts at 20:23:10. If you'd play this portion, please.
How long I gotta hold you down? How long I gotta put on? Right.
And then, just having reviewed that video, I'd like to show you what's.
Did y'all see in that video where Floyd almost knocked Chauvin off him, and Chauvin had to use the car for balance because Floyd's resistive rolling, even with three officers, threw Chauvin off balance. Watch him grab the car when he gets thrown off balance.
Just having reviewed that video.
How long I gotta hold you down?
Right there. He was thrown off balance because almost he got up and he rolled the officer's weight forward, which tells me Chauvin's weight was to the rear, and when he started resisting, he tried to use more weight, and because Floyd rolled, it almost threw him forward into the car, and that's why he had to use his hand right here to prevent him from going into the car. I can't believe they haven't pointed that out.
Right.
And then, just having reviewed that video, I'd like to show you what's been marked as demonstrative exhibit 947. 947. All right, so in demonstrative exhibit 947, you see it's a still frame captured from composite, I guess, or the exhibit 15, which has been received into evidence at the time. It's not military time, but it's 8/23/14. And this is roughly corresponding with the clip I just showed you. Can you show, do you see the defendant's, the foot on his left leg?
They're going to try and send this guy to prison because of a snapshot of his toe off the ground. I always say when people are investigating homicides, every little thing matters. This one snapshot right here could be the difference of him getting convicted or not.
Yes.
And do you see how it's slightly off the ground?
Yes.
Now, you would agree that, given the orientation of the defendant's foot at this particular moment in time, there would be more pressure placed on Mr. Floyd's neck and back. True?
It's possible.
It's more than possible, isn't it? I mean,
So the reason why I say possible is that Mr. Floyd's movements could have, in that moment, taken Mr. Chauvin's foot off the ground.
let's take a look at that clip we just watched again, please.
Restraint.
Yep, that's right.
You can tell he's having a hard time balancing. He is moving this 140-pound guy around on top of him.
Yep, that's right.
How long I gotta hold you down? Now you don't gotta put on. Right.
Are those the movements you're talking about that could have moved his foot up?
Yes, and I saw the officer reach out for a little balance by supporting his left hand up against the back of the squad car.
And the balance issue is important because when you place yourself both knees on a person, that's not a very good balance point, is it?
It depends.
Well, apparently it wasn't here if the defendant was trying to balance himself against the car, correct?
Or he's just responding to Mr. Floyd's movements.
Maybe he wasn't battling himself. Maybe Mr. Floyd's strength, superhuman strength, because he was on drugs and wasn't feeling pain, threw him off balance and forced him into the car. And had he not used his arm to prevent him from hitting the car, he would have got thrown off balance and could have got knocked off.
And as you saw in the portion that you looked at, the defendant's body weight was not being supported by his foot because his foot was off the ground, correct?
At that moment that the picture was taken, yes.
And that would increase the pressure on Mr. Floyd.
Maybe.
Whether
Like I
he's
said
moving
earlier,
or
it could
not.
be in response to his movement.
Whether it's in response to his movement or not, the question is, would it increase the pressure? Would it increase the pressure?
I don't know.
Good answer. Prove it. If you're so sure, prove it.
All right. We've discussed a little bit about the defendant's initial use of force to restrain Mr. Floyd. Right? And I'd like to discuss now what happens next. As you've analyzed all of these videos, but it's important that we get the full scope of your opinion here. So we're going to go back to Exhibit 127 and begin at clip 20.
He doesn't want his opinion. He wants to prove his opinion wrong and show pictures that go against what he says.
1923. And if you can start playing now.
Jesus Christ. Okay, breathe. Okay, thank you. Okay, breathe. Samu.
Thank you. So during that segment, that was about 9 seconds, the beginning of it was about 9 seconds after Mr. Floyd was placed in the prone position. Would you agree?
Yes.
And during that period of time, you heard Mr. Floyd say multiple times, "I can't breathe." True?
Yes.
I also heard him say that multiple times before they got him on the ground, which means he lost credibility, which is why the officer started ignoring what he's saying, because he was saying all kind of things. He had excuses for everything, but his actions, not listening to his words, was still resistive, and he was trying to get up.
Did you count how many times?
No.
I counted 6. Would you have any reason to dispute that?
No.
And obviously the defendant would know, a reasonable officer would know, that this prone position could present a danger of positional asphyxia. True?
It's potential.
And that it's important then, in terms of situational awareness, to not only be aware of that training and prior knowledge, but to pay attention to what the subject is saying, correct?
Depends.
And the subject here is saying multiple times, "I can't breathe," correct?
That's correct.
Now, I think your testimony earlier said there can be times in which people...
See how he's got this rapid fire? I talked about this earlier. when they get a witness on the hooks and they get a witness to just answer yes, yes, no, yes, yes, do you agree, yes, 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 then they slide in a critical question. You're so used and routine to say yes, 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 you end up answering it. You got to break their rhythm when they're working you. Right now, the DA is working this witness.
People can say they don't breathe and don't mean it, right?
Yes.
Maybe faking it, I guess, right?
Good.
But context is really everything, isn't it?
Can be.
Because part of the reasonable police officer analysis assumes that you have a reasonable person applying the standards
Who thinks the DA is doing more testifying than the guy on the stand?
and using a little bit of their common sense. Fair?
Yes.
All right. And so if I have I'm standing here talking to you normally in a normal tone, in a normal voice, and I tell you, I can't breathe. I'm standing here, I'm talking to you, you might have reason to doubt me, correct?
Yes.
But in a situation where we have here, where you're actually physically on top of someone, in a position which, based on your training, and based on your experience, and based on your knowledge, could cause positional asphyxia, that's a different context, correct?
Yes.
It would be a different context if that was the first time he said it. And you would agree that he had said it so many times before when I wasn't on him or when the officer wasn't on him, then why should I believe him? And why wouldn't a reasonable officer believe that he's saying the same thing he was saying when he was standing up? And that's why the threat wasn't taken as a real and plausible threat that maybe he really couldn't breathe.
And in that context, a reasonable police officer would at least acknowledge and consider the possibility that what they're doing is causing a problem, wouldn't they?
We would
Depends.
interpret what Mr. Floyd is doing while he's making the statements, and it appeared to me with that video that he was still struggling.
Struggling or writhing?
I don't know the difference.
Well, would a reasonable police officer on the scene consider whether somebody is actively resisting or writhing on the ground because they can't breathe?
I think it'd be reasonable for the officer to take what Mr. Floyd had been doing prior to that and still consider that he was struggling.
And prior to
Agreed.
that, you would acknowledge that there was a physical struggle, correct?
Yes.
Physical struggles can be exhausting, correct?
They can.
That's exhaustion is based on your training and your knowledge and your experience, another potential risk factor associated with positional asphyxia, true?
Can be, yes.
It can complicate things, true?
Yes.
As can intoxication, true?
True, true,
Alcohol or
true,
drug?
true.
Let's start with alcohol.
I don't know.
Okay? Drug intoxication could also be a risk factor with positional asphyxia, true?
It can.
And when we talk about some of the different factors and things that we've known at the scene, a reasonable police officer in the defendant's position would have taken those factors into account as well, true?
Yes.
From his vantage point on top of Mr. Floyd, fair?
Yes.
We take our technology break at this point, Judge?
Yeah.
All right.
Take a 20-minute break.
Go back to 320.
Okay, we're 57 minutes. I guess we'll come back on this guy again. The prosecution's having a field day with him. All right, we'll end that one, start a new one.